welcome everyone to the first event for the academic year for the Donia Human Rights Center at the University of Michigan. I'm Steve Ratner. I'm a professor of international law at the University of Michigan Law School, and I'm delighted to welcome all of you. We have over 170 participants in this meeting joining us today for this webinar. I hope we'll be able to make the transition to in-house meetings before too long. I want to start our webinar by acknowledging that our event is taking place in the midst of a work action by the Graduate Employees Organization against the University of Michigan administration. I'd like to express my strong support for our graduate students whose commitment to the university and our undergraduates is unwavering. It's my sincerest hope that the negotiations underway between the GEO and the administration will very soon lead to an end to their strike. We're having this panel today because it addresses one of the most important moral and political issues of our time. And as the director of the Donia Human Rights Center, I believe that the center has an obligation to help the Michigan community think and learn about the manifold strategies to address systemic racism, including those that to date have not received very much attention. And so I appreciate everyone's understanding, and I look forward to our panel discussion today. The last 6 months have been tumultuous in the United States. The murders of African Americans by law enforcement have changed the national political and moral landscape. In particular, the March 13th killing of Breonna Taylor by Louisville police at home and unarmed, the exposure in April of the murder in February of Ahmaud Arbery by a group of whites while jogging, and the May 25th murder of George Floyd by Minneapolis police, captured live by witnesses, have galvanized white public attention on racism in the United States in ways that countless other killings of African Americans by police and vigilantes have not. Public protests and debates have centered on a range of issues, from accountability of the immediate perpetrators to reform and defunding of police departments, to dismantling other structural aspects of racism that permeate education, housing, and other aspects of society. What has only occasionally been part of the debates over America's experience with racism has been the reality that discrimination, of course, is a global, discrimination based on color is a global phenomenon. And that with that phenomenon has come numerous global norms and rules, which we call international human rights. Those include numerous treaties banning racial discrimination, containing rules on police and court conduct, and mandating remedies for victims and prosecutions. Among these treaties are the International Covenant on Civil and Political Rights, the Convention on the Elimination of All Forms of Racial Discrimination, and the Convention Against Torture. The US is a party to all three of these treaties and bound by their provisions, but it has failed in significant ways to carry out their provisions. International bodies and NGOs that have criticized systemic racism in the United States are often met by dismissal or even outrage by groups within the United States. In addition to these international rules, Americans should look at the experiences of other countries at incorporating international law into their practices. For many jurisdictions outside the United States have found ways to use these international rules to respond to violations of human rights based on race. To help us understand the potential and limitations of international human rights as a lens for addressing problems of racism and race relations, I'm delighted to introduce our highly distinguished panelists. First is Catherine Powell, professor at Fordham Law School, where she teaches in constitutional law, human rights, and digital rights. Her current work focuses on the role of race and gender in our emerging touchless society and the ways that it amplifies structural inequalities. Her prior experiences include stints on President Obama's White House National Security Council staff and Secretary of State Clinton's policy planning staff. She's the first Black woman academic to serve on the board of editors of the American Journal of International Law and sits on the American Society of International Law's Executive Council and chairs its organization known as the Blacks of the American Society of International Law, and she was previously on the board of directors of Human Rights Watch. Yasmin Suka joins us from Johannesburg this afternoon. Ms. Suka is the former executive director of the Foundation for Human Rights in South Africa. She served as a member of the South African Truth and Reconciliation Commission from 1996 to 2001 and chaired the committee of that commission responsible for its seminal and highly important final report that was issued in early 2000s. Since that time, she has been appointed by the UN to serve on the Truth and Reconciliation Commission of Sierra Leone from 2002 to 2004. She's been on the advisory body for the UN Human Security Council's resolution on women, peace, and security. In 2010 and 2011, I had the privilege of serving with Yasmin on the Secretary General's three-person panel of experts on accountability in Sri Lanka. And since that time, she is currently serving as the chair of the UN Commission of Human Rights, Council on Human Rights, Commission of Inquiry regarding South Sudan. Our third panelist was to be Hardy Vieux of Human Rights First. Hardy has decided not to participate in today's meeting because of the strike. I look forward, and Hardy looks forward to another occasion in the future to joining us for a Donia Center event. So let me just say a few brief logistical matters before we start with Professor Powell. Each of our speakers will give some introductory thoughts for 10, 15 minutes or so. I will then follow up with some follow-up questions to have a conversation with the two of them. And then we will take questions from the audience. There is a question and answer bar. Please do not start typing questions until towards the end of the discussion period. So please wait until the initial presentations are over so that I am not overwhelmed with trying to sift through the question and answer bar. I will be synthesizing those questions. If you do type a question in, and we certainly do encourage you to do so, please put your affiliation. We like to call on students first, so please indicate University of Michigan undergrad, University of Chicago graduate student, whoever you are, and I will do my best to get as many of these questions answered or posed to our panelists as we can in the time that we have. So with that said, I turn the floor over to Professor Catherine Powell of Fordham Law School.
Thank you so much, Professor Ratner. It's really an honor to join you. I have so much respect for Steve Ratner, and also want to acknowledge Brenna Warner and the whole Michigan Human Rights team and my co-panelists. I'd like to also acknowledge the graduate students striking and express my support with labor. I think it's also important that I start by acknowledging the traditional and sacred lands on which we sit, particularly for those of us who work in New York, the Lenape people. We are very honored, I feel very honored to be able to work, share, and collaborate on and create on these lands. Today, I want to mainly aim my remarks at three human rights principles. First, the idea of a bolder approach to rights than we have under domestic law. Second, the notion that all human rights work must start from the bottom and be led by those whose lives are mostly affected. And third, by acknowledging the interdependence of rights, the idea that civil and political rights depend on economic rights and the rights of the poor, that work around racial justice depends on gender justice, and other forms of justice are interrelated. Catherine McKinnon reminded us when I was a student and took a class with her when she visited that international law, human rights law, is long on principle but short on enforcement. As the first chair of the UN Human Rights Committee, Eleanor Roosevelt said, "Where, after all, do universal human rights begin? Close to home." Well, we're at an inflection point, not only close to home, but globally. One that could shift norms, if not enforcement. We're in a moment of interlocking pandemics, not only a health pandemic, but a pandemic of policing, poverty, and protest. George Floyd and Eric Garner were arrested for crimes of poverty. We live in a time of record-breaking unemployment, of economic insecurity, accelerated by a health crisis, a crisis that unmasks structural inequality baked into the foundation of our Constitution, a Constitution that disenfranchised Blacks, women, Native Americans, and others without property. I'd like to reflect on this moment of converging pandemics to explore what we mean by freedom. And then I'll introduce a new concept I'm developing in my work around viral convergence toward a more just future, and would love to, in conversation, unpack this more. The US Constitution was one of the earliest human rights documents, right? It was designed as a safeguard against freedom, against King George, against tyranny. It was one of the first documents to indicate that all people had rights, certain basic rights, simply by virtue of our humanity. But what kind of freedom? And freedom for whom? Let me start with 4 familiar stories, and I'm going to ground these stories in some remarks that sociologist Ruha Benjamin offered this past summer, but these stories will be familiar to you, and I'll ground them in more explicitly in the human rights framework. Story number 1, we are free. Free to do essential work without health benefits, free to nurse the sick without personal protective gear, free to harvest the nation's food in the shadow of immigration raids, free to incarcerate, to be incarcerated with no way to social distance, freedom not to care as the most vulnerable among us die off. This approach to freedom is grounded in classical liberalism that we associate with our original Constitution of 1787. And yet it's not clear that this is the kind of notion that Rousseau or Locke had in mind when they theorized social contract theory. Because in its purest form, as Ruha Benjamin reminds us, the aim of this strain of freedom is to erode mutuality, to destroy the care economy, to undercut the notion of a collective good, and to destroy the institutions upon which society depends, a free press, an independent judiciary, and other checks and balances. This distortion of freedom, the freedom not to care, and is really a freedom not to care. And yet at its best, it should mean a right to simply be left alone. Story number 2. This past March, Breonna Taylor and her boyfriend Kenneth were sleeping in their Louisville apartment when they heard a loud noise in the middle of the night. Breonna was an EMT covering 2 hospitals and an aspiring nurse. Kenneth was a postal worker. They were among the numerous essential workers. As I've discussed in a recent CNN op-ed in which I coined the term color of COVID, I discussed the racial justice paradox that's built into our stay-at-home economy. Black and Latinx folks are overrepresented as essential workers and Amazon warehouse workers, as delivery and postal workers who bring packages to our front door that enable many of us to work and study from home. But Black and Latinx are also overrepresented among the unemployed and are hardest hit from the recent job losses. We see this duality among women as well. Women are overrepresented as frontline workers, part of the invisible workforce that keeps the country running, ranging from grocery store checkout clerks, home health care providers, and other healthcare and healthcare adjacent jobs. While on the unemployment side of the coin, women have lost jobs in retail, as cleaners in hotel, and in restaurant and childcare sectors. Breonna's mother, Tamika Palmer, notes the irony of her daughters having been an essential worker. Her biggest concern had been Breonna's safety as a healthcare worker, rather than her daughter's safety in her own home. Many of us can relate, right? We worry about whether we're washing our hands enough, not whether the police are gonna come bust down the door on a no-knock warrant. Story number 3. Police officer Derek Chauvin, hand in pocket, bearing the full weight of his body, knee on George Floyd's neck for 8 minutes and 46 seconds. Please, 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 George Floyd gasped, calling the name of his dead mother. In disbelief, onlookers told the police, "He's not responsive right now, bro." Some with cameras, "He's not effing moving." Sunglasses perched on head. Derek Chauvin's indifference underscored what freedom often means for Black and brown people. Jogging while Black, bird watching while Black, sleeping while Black. Black folks can't even be in a pandemic regular, poet Bettina Judd laments. Turns out George Floyd had not only just lost his job, he had recently tested positive for COVID. His case was the perfect storm of the interlocking pandemics we experienced this summer. A virus, the virus of COVID, the virus of racism, and the virus of economic insecurity. As Ruha Benjamin notes, whether Black people die because of COVID, because of deadly policies, or at the hands of police under the mask of law and order, underlying health conditions of individuals, rather than the sickening conditions of society, are predictable alibis. Racism-related vigilance has long been a survival tool for Black folks. Putting on a shield or mask, and relatedly the notion of double consciousness that W.B. Du Bois talked about, has been a survival strategy long before COVID, long before George Floyd. But as one journal, health journal notes, many Black men fear wearing the mask more than coronavirus for fear of being mistaken as a criminal, unless the mask is clearly a protective one for COVID. As one African-American man tweeted, "I want to stay alive, but I want to stay alive." When we saw Blacks arrested on the streets of New York City this summer for not wearing a mask, as the picture here on the bottom, while whites were permitted to sunbathe in the city's parks, it became clear that the real issue wasn't the mask. The real issue is, and has always been, Blackness. When we saw how Colin Kaepernick was shunned from the NFL for peacefully protesting during the national anthem, and yet armed men this past summer were able to protest quarantine measures, the issue is, and has always been, Blackness. In my work, I explore race, gender, and nation as a way of interrogating belonging and inclusion. In a recent article I co-wrote this summer in Georgetown Law Journal called "The Welfare Queen Goes to the Polls," my co-author and I interrogate how race, gender, and poverty are pathologized and mobilized today in the context of voter suppression or immigrant women, yesterday or in earlier times to deny welfare benefits to poor women. We discovered that Black suffragists Frederick Douglass and Frances Harper explicitly used the language of human rights rather than civil rights to underscore that Blacks and women were, quote, all bound up together, as Frances Harper put it. The voting rights of both were bound up together. Many of us are taught that violations of rights are isolated incidents, a few bad apples, but we must not lose sight of the fact that of the systemic, constructive, and even productive role that race plays. Ruha Benjamin reminds us that racism is socially constructed, but we often fail to state the corollary, that racism constructs. But over the summer, something happened in the aftermath of George Floyd's murder. We saw tens of thousands of peaceful protesters linking the need for racial justice at home and abroad, from Brooklyn to Portland and Kenosha, from Paris to Idlib, Syria. People around the world began demanding transformational change, organized around the types of bold rights that we see in international human rights law. The UN Human Rights Council organized an urgent debate on racism, systemic racism, police brutality, and violence against peaceful protesters. And an incredible turnabout. Athletes across the board began to demonstrate a variety of forms of solidarity for Black lives. Confederate statues and monuments began to tumble down. Aunt Jemima was taken off our breakfast syrup. Tech giants Microsoft and Amazon ended the use of facial recognition. One final story. Our health care policies are shortening our lives. Our education policies manufacture ignorance. Our labor policies produce disposable people rather than truly essential and valued workers. Our housing policies create scarcity. The gutting of environmental regulations ensures our collective self-destruction, as we see in the wildfires out west and really around the world. The government should be nurturing our collective sense of well-being instead of tearing us apart. During Reconstruction, the notion of 40 acres and a mule was intended to reflect that we couldn't have civil and political rights without also guaranteeing minimal entitlements to land. After World War II, FDR reminded us that there are 4 freedoms, not only the freedom of speech and of religion, but freedom from want and freedom from fear. He proposed a second Bill of Rights in Congress to address poverty and economic rights. I want to conclude by ending with the insights offered by Arundhati Roy that we could use this pandemic as a portal to a more just future. Or Ruha Benjamin's call for viral justice to recoup the virality of disease and the virality of racism. The virus need not be the viral need not be superficial, like a fleeting tweet or meme. The hashtag is a perfect example of the accumulation of many connected individual acts. And Derek Bell offered the notion of interest convergence that highlights that African American gains for civil rights only really occur when they converge with the interest of whites and are relatively cost-free and cause little inconvenience. Combining these insights, I'm developing a notion of viral convergence which is really based on the human rights idea. That is, that we use this moment in which we are all vulnerable to find solutions that protect the most marginalized in our community, and in so doing, find solutions for us all.
Thank you very much, Professor Powell. That was really just a wonderful way to start our event today. So Yasmin Suka in Johannesburg, I'm delighted to ask you to offer us some of your introductory thoughts. Thanks so much for joining us.
Thank you. I'd like to thank Steve and the Donia Human Rights Center for inviting me to participate in the seminar. I'd also like to express my solidarity with the graduate students who really are fighting a just cause. And while every situation in the world is unique, in my own country, South Africa, we have grappled with very similar problems to what you are grappling with in the United States in terms of race, structural racism, and of course, race relations. South Africa is a country which experienced racism and racial discrimination going right back to the colonial period. And during this period, Black people in my country were not only robbed of their ancestral land, but by 1913, the dispossession was complete. And this brutal dispossession saw people brutally removed to black spots known as homelands, modeled on Canadian reservations, in which they were forced to eke out a living with no support at all. The men became a cheap labor resource for the mines, leaving behind women and children in the rural areas of South Africa, creating new migrant populations. And of course, when the apartheid government came to power in 1948, they completed the racial project, and racism and racial discrimination became entrenched by law and impacted on every facet of our lives. Race and color determined your classification, either as white, colored, Indian, or Black. Your race classification would be determined by a bureaucrat on the basis of one's hair or the color of your skin, and ridiculously, whether you had a crescent on the bottom of your nail. But more fundamentally was dehumanization, with our rights to equality and dignity eroded completely, as it determined access to education, racially divided schools, spatially where you lived, transportation, economic access, employment, and which university you attended. Under apartheid, the government made clear that Black people should only be educated sufficiently to be the drawers of water and the hewers of wood. Job reservation was entrenched in our law, and today, not many of the white beneficiaries of apartheid admit to being supporters of that government. However, what they forget was that they voted overwhelmingly to put them back into power with enormous wins in successive elections. And so our reality was institutionalized and structural racism underpinned by law and policy. And on the international front, during this period of apartheid between 1948 and 1990, South Africa was in conflict with both the international community and international law. Apartheid was premised on race discrimination and the denial of human rights, which was contrary both to the UN Charter and to the norms of UN human rights, non-discrimination, and self-determination. Our foreign policy was based on the law of state sovereignty and absolute respect for domestic jurisdiction. And so by 1960, after the Sharpeville massacre, in which more than 60 people had been gunned down in cold blood by the apartheid police, South Africa became a pariah state within the international community. And by 1977, apartheid was declared a crime against humanity, and South Africa became a delinquent state in the context of the new international law of human rights. Domestically, international law fared little better, and customary international law was treated with great hostility by successive apartheid governments. It was not surprising, therefore, that international law received no constitutional recognition and was largely ignored by courts and lawyers. But of course, a dramatic change came with the transition from apartheid to democracy. Today, South Africa is a democratic state with a democratically elected parliament, entrenched human rights and racial equality in its constitution, and adopting a new attitude towards international law. Whereas international law was previously seen as a threat, it's now viewed as one of the pillars of the new democracy. And the South African Truth and Reconciliation Commission, which I was part of, was established as a result of a compromise to deal with the horrific gross human rights violations that had taken place in our past, and really embodied the obligations of our country to deal with its ugly past. The new Constitution of South Africa was signed into law by President Mandela on the 10th of December 1996. And appropriately, this ceremony took place on Human Rights Day at Sharpeville, the scene of the massacre of African demonstrators against the laws of apartheid in 1960. In President Mandela's address to the Constitutional Assembly, he described the kind of society that South Africa was trying to build. And he said that the Constitution was our humble contribution to democracy and to the culture of human rights worldwide. And it is our pledge to humanity that nothing will steer us from this cause. So following the transition, South Africa passed a number of laws to give effect to the constitutional goals of achieving equality, human dignity, and the advancement of human rights and freedoms. And during the first 20 years of democracy, more than 1,200 laws and amendments were passed aimed at dismantling apartheid and eradicating all forms of discrimination. New and amended legislation was put into place to enforce equality and to prevent discrimination, such as, for example, the Employment Equity Act, the Promotion of Access to Information Act, and the Promotion of Equality and Prevention of Unfair Discrimination Act. And so, in terms of our Constitution, customary international law is considered to be part of South African law, and the courts are required to ascertain and administer rules of customary international law. And the common law was given constitutional endorsement by Section 232 of our Constitution. And customary international law is the law in the Republic of South Africa unless it is inconsistent with the Constitution or an act of Parliament. But let me go to the question really of dealing with racism, racial discrimination, and the whole question of xenophobia, which is a problem in South Africa as well. The interim constitution and the 1996 constitution contains a Bill of Rights which guarantees the rights protected by international human rights conventions. And whereas the interim constitution confined itself largely to civil and political rights, the final constitution extended its protection to both civil and political and socioeconomic and cultural rights. And in fact, this made socioeconomic rights justiciable. And this, of course, was in response to a constitutional principle which provides that everyone shall enjoy all universally accepted fundamental rights, freedoms, and liberties. And these are protected in the Constitution and by a constitutional court with a wide power of judicial review over legislation and administrative action. The International Convention on the Elimination of All Forms of Racial Discrimination was signed into effect in South Africa in 1994 and ratified 5 years later. And so as far as South Africa is concerned, the ICIRD entered into force, becoming binding on the 9th of January 1999. Of course, South Africa hosted the historic Durban Conference on Racism in 2001, where governments, diplomatic representatives, international agencies, and civil society groups converged at the World Conference on Racism, Racial Discrimination, Xenophobia, and Related Intolerance, and produced the Durban Declaration and Program of Action, which remains really the most important framework to date for combating racism, racial discrimination, and xenophobia. South Africa also ratified the ICIRD, the International Covenant on Civil and Political Rights, and of course the International Covenant on Economic, Social, and Cultural Rights. And these provisions influence law and policy and jurisprudence in our country. In 2017, we finally produced a national action plan to combat racism, which is completely informed by our treaty obligations and include the international covenants that I've mentioned. In Article 150 of the NAP, mention is made of customary international law and the need for consistency with the state's international and domestic obligations. In terms, of course, of jurisprudence around these questions, South Africa's Constitutional Court has adopted a view on non-racialism, which is also the dominant view in South Africa in political discourse. And this is really the question of how we view non-racialism. And the courts have said that while this is an ideal, it can only be reached by accepting the reality that race has a profound effect on how we view people, how the world is arranged, and what life chances individuals enjoy. And in other words, in order to create a non-racial society, it is necessary to acknowledge and to deal with the effects of lingering racism and formal and informal racial discrimination. And to do that, one has to acknowledge that race, in fact, continues to have real-life consequences. In another Constitutional Court decision, the judge said that, however, it is also clear that the long-term goal of our society is a non-racial, non-sexist society in which each person will be recognized and treated as a human being of equal worth and dignity. But central to this vision is the recognition that ours is a diverse society comprised of people of different races, different language groups, different religions, and of course of a range of different sexes. This is diversity, and our equality as citizens within it is something our Constitution celebrates and protects. And one way to understand this approach is to distinguish, on the one hand, between the notion that race is an invented or constructed concept which does not say anything profound or accurate about any human being, and on the other hand, the idea that race may be an invented concept but nevertheless has material effects, which means avoiding the use of race as a legal concept would make it difficult, if not impossible, for the law to respond to the consequences of racism and white supremacy. And this has become quite an important issue in South Africa, that the notion that even though one has the question of equality, in constructing that equality, one needs to acknowledge that race impacts on the lived reality of those on the receiving end of racism and racial discrimination, and in fact is to condone existing inequality. So in this fundamental way, our constitution differs from other constitutions, which assume that all are equal, and in so doing, simply entrench existing inequalities. Our constitution recognizes that decades of systematic racial discrimination entrenched by the apartheid legal order cannot be eliminated without positive action being taken to achieve that result. We are required to do more. The effects of discrimination may continue indefinitely unless there is a commitment to end it. And at the heart of this approach is an acknowledgement that the constitutional claim that everyone is equal before the law is the expression of an ideal. It's not a description of reality. Everyone's not equal before the law, partly because of the way in which race and racism and gender impact differently on different people. And in this view, the claim that we are all equal makes this impossible, and that race does not exist is a dangerous one, as it may serve to hide the many different ways in which racism impacts on people who are not white. In short, this is a view that a colorblind approach to race inevitably leads to turning a blind eye to racism and its consequences. In South Africa, the equality courts have dealt with a number of cases of racism and racial discrimination. International law is sometimes referenced in these cases that are mainly decided on the basis of the Constitution, and in terms of the Constitution, race is considered to be an important aspect. I'll stop there and we can get into some of the discussion on some of the cases that have arisen in South Africa. Thank you.
Thank you very much for those wonderful remarks and really so much food for thought as we start our conversation. So I'm going to just ask a few follow-up questions and have a discussion, try to encourage a discussion. Those of you who are watching the webinar, if you can say question from Michigan student or whatever, I will do my best to start posing those once we're done with this portion. One of the issues that's particularly challenging with respect to human rights in this country is trying to invoke human rights as opposed to civil rights. And you mentioned, Catherine, that even back in the early days of suffrage and early days of this pre-civil rights movement, that the notion of human rights had been invoked as a way of encouraging solidarity between African Americans and women. I just was wondering from both of you, to what extent outside of courts do you see there being a challenge to having a dialogue that is talking about human rights and all that it implies and that it means, as opposed to one about civil rights? And why might it be that that invocation of human rights has been less successful in the United States than in South Africa, if that is the case? But I'd be interested in, I guess, in the South African case, the difference between a human right and a constitutional right, and how conversations change when those two terms are used by different advocates. So, Catherine, would you like to start with your thoughts maybe on that?
Yeah, well, as you know, Steve, I work very closely with Lou Hinken and co-taught with him, who had really written quite a bit about how the human rights idea comes out of those revolutionary moments from the 17th century, the American Revolution and the French Revolution, that, the idea that we all are created equal, as Thomas Jefferson said, and that we all have inherent rights simply by virtue of our humanity. So in a way, we forget that the American Declaration and the US Constitution are human rights documents. You know, in many ways, the idea of human rights comes very naturally to Black intellectuals because we didn't have civil rights. And so instead, because our rights weren't, slavery was enshrined in the Constitution, we reached to a broader concept of human rights. And that's why Frederick Douglass very explicitly used the term human rights, as did Francis Harper, who worked in both both of them worked in the abolition and suffrage movement. Martin Luther King as well, as did Malcolm X. Following World War II, it was the Anti-Defamation League and the NAACP that worked together to get the human rights language in the UN Charter, right? And so many civil rights groups have embraced the human rights idea, even if we can't litigate international human rights instruments in court. I think South Africa, being a newer country, is more embracing of the modern idea of human rights than the US is. But we see on the streets this summer, one slide I didn't show, but was of a sign saying housing is a human right because of the evictions we're seeing, the threatened evictions with people not being able to pay their rent this summer. And so I think people are coming back around to that, especially where there's qualified immunity, different ways of restricting rights, and accountability against police to people are kind of coming back to the idea of human rights as a way of linking a variety of different rights concerns.
Thank you, Steve. I mean, it's a really interesting question because remember, I guess the emergence of a kind of human rights culture in South Africa is directly linked to the fact that for more than 350 years, we had no rights. And so for us, embracing the question of human rights was really part of reclaiming the notion of our humanity and dignity. But I think what we also see in the last 5 years is, as South Africa has not been able to fulfill its commitments around the Constitution to ordinary South Africans, there's quite a disenchantment with the notion of whether the Constitution delivers for all. And in fact, as a young person that I spoke to who was part of the Fees Must Fall and the Rhodes Statute Must Fall movement in South Africa said, I can't eat the Constitution. It's just a document on a piece of paper. And until such time as it delivers for me, I really don't appreciate it at all. And there's a notion that this is part of a liberal democracy idea and not something that really benefits ordinary South Africans. And so I do think that, in South Africa, even though socioeconomic rights are justiciable in terms of the Constitution, when you begin to look at the way in which the Constitution has been used, it's largely been used by liberal interest groups, and in terms of which civil and political rights have largely been entrenched. And even when it comes to the socioeconomic rights dimension, what you've seen are administrative orders, and it really hasn't yet been used to tackle the thorny issue of land dispossession, and of course, used in a radical way to transform really anti-poor and anti-marginalization policies. And so what we are beginning to say is that if we're going to understand that the Constitution is a promise of a better life for all, then there has to be a much more radical interpretation of the Constitution, and it has to be used to deal with the rights for the most poor. And of course, during this time of COVID, I think what we have seen is that all the fault lines in our society are laid bare. And, the way in which there has been the neglect of health systems, the fact that it's the most poor, and it's always a race issue when it comes to essential workers, when it comes to the people who are the most exposed. Even the notion of social distancing became quite a mockery, because if you live in an informal settlement, then how do you social distance? How do you deal with healthcare when you don't have access to clean water? And so I think that while we claim the language of human rights, there's this disconnect with the Constitution. And this is really where the battle lines are going to be drawn in the next few years in South Africa.
Thanks very much for your answers. I just building on that question. We see so many differences between the approaches. Of course, the demography and the history is so vastly different that there's lots of reasons for these different approaches to thinking about human rights. But I guess I was just wondering, and perhaps some people in our audience are as well, whether the receptivity of South Africa to international human rights offers any possible lessons of transmission to quite a different country like the United States, a majority white country, at least for now, but soon to be a majority minority country. Is there any, given the vast differences in history and in so many other differences, are there positive lessons from the South African approach to human rights that can be perhaps taken on by the United States? And I suppose for Catherine, the corresponding question would be is, how likely do you see those human rights approaches to be accepted, and what are the barriers to bringing human rights, international human rights, not simply into courts, because we know that's hard, but into legislation, conversations, the way they seem to be part of the conversation in South Africa? So Yasmin, any possible lessons for the United States from the South African experience?
I'm remembering to unmute. It's a really interesting question, because in many ways, I guess that for South Africans, it was almost natural to kind of reach out to international law and to incorporate international law into the South African Constitution. And of course, Section 232 of the Constitution, which makes customary international law a part of South African law, and we really use that to transform the common law in South Africa, which is where our courts traditionally went. And that's really, I guess, to some extent because of our own history of almost being seen as the whole struggle for apartheid, against apartheid was so internationalized that it was almost quite natural to do that kind of incorporation. At the same time, one of the challenges, of course, in South Africa was that we also had the sunset clause, and there was no real vetting and screening and lustration in terms of the judiciary. And in fact, many of the lawyers in South Africa were not steeped in constitutionalism or in international law. And so a lot of the kind of jurisprudential transformation that you have seen have come from people who have taken cases to court. And in fact, the foundation at which which I ran for about 19 years, was at the forefront of taking many cases to the Constitutional Court. And that was really around the questions of transformation, around how access to housing, the access to AIDS, drugs, etc., all of that kind of thing. But I also think that one of the lessons really is the dominance in the legal system of lawyers who come from a very positivist tradition and who see civil and political rights as almost a first tier of rights, and don't really appreciate the socioeconomic rights dimension. And one must remember that that was also a bitterly won issue in the South African Constitution, and it is the difference between the interim constitution and the final constitution, with most liberal lawyers in fact feeling that they lost the battle on the socioeconomic rights dimension. And so when it comes to this question of transformation, and of course the courts are the place where one plays these legal battles out, for me, that's where I see a new generation of lawyers really having to take the cudgels up. And that's the lesson. Really, one has to see rights as indivisible. And of course, unless you incorporate within that the struggle for gender equality as well, I think what you find is that at some levels, you lose out on the other side. And so it's no accident that when you look at a country like South Africa, gender-based violence is, it's at an extremely high level. And in fact, we talk about that almost as another pandemic. And so I would argue that in moving forward in terms of the question of how you use the law and international law, I would say you have to see the intersectionality question, and you also have to look at it from the perspective of rights indivisibility, but taking up the cudgels for socioeconomic rights and cultural rights as well.
Maybe just to piggyback on that really quickly, 2 points. One, actually, I saw a question in the chat box is about the Truth and Reconciliation Commission in South Africa. And so in terms of lessons we can learn from abroad, human rights lessons, there is talk now of creating a Truth Commission. Barbara Lee, Congresswoman Lee has proposed that. When Obama came to office, there was talk of doing a Truth Commission on the question of torture and accountability, rather than, and debates about whether there should be prosecutions or a Truth Commission. Obama, in effect, chose neither. He said he wanted to he wanted to move forward, turn the page rather than look backwards. He needed Republican support for health reform and so forth. And so he chose not to push for a Truth Commission. Whether, if there's a change in Washington, whether we'll see a Truth Commission is an open question. But it'd be interesting to hear from Yasmin what she thinks about those possibilities. But just the second quick point I was going to make is that when Obama came to office, I was part of a coalition of activists that developed a Bringing Human Rights Home report, where we proposed that the Obama administration both restart the U.S. Civil Rights Commission, which is pretty much dysfunctional institution created in the 60s, and that did really serious field work that helped pave the way for the Civil Rights Act by documenting voting rights violations. Father Hesburgh, who was the founding chair of the Civil Rights Commission, wanted it to be a human rights commission to focus on poverty and race. And so our proposal was that Obama reauthorize it as a civil and human rights commission, as many around the world, many countries have human rights commissions. My understanding is that the proposal actually made it to the president's desk, and he was interested in it when I worked in the White House. However, Republicans won the Senate in the midterm elections, and he figured he couldn't get support for it because Congress would have had to reauthorize. But we also were pushing for an update on Bill Clinton's human rights executive order to implement human rights at home. Instead of trying to get a new executive order, we just created a working group in government, on an equality working group that helped all the different civil rights offices across the interagency coordinate, really using a human rights principle that the various issues were interrelated. And Tom, the guy who's the head of the DNC now, anyway, that guy, Tom, he was the head of the Civil Rights Division in the Justice Department.
Yes.
And yes. He coordinated this equality working group, which was really a civil and human rights working group. We didn't publicize it, we just sort of did it as a way of recognizing the way the different rights across the agencies were interrelated. So I think there's a receptivity, not so much in the courts, again, it's so difficult, but more in terms of policy making and activism, and the possibility of administrative agencies like the Civil Rights Commission.
Very interesting. This is, I think since we have a couple, I've noticed several questions that are directly relevant to this conversation. I'm going to try to synthesize them so we can just sort of stay on this topic for a moment. One from Emma McFarland, a University of Michigan law student. One from Christian Casanova, who's a master's student in health informatics, and another from someone who hasn't identified himself, but they're all basically asking the same question, which is about sort of post-conflict justice. And they raise the question about whether Truth Commission, reparations, and apology are, which are all part of the sort of toolkit for transitional justice that has been developed by the UN and by international bodies, and that was something that Yasmin and I engaged with in our recommendations to the Sri Lankan government after their civil war. Whether those three strategies, which are part of the South African experience, have any promise in the United States? So I guess I'll start with asking Yasmin that question about Truth Commission, reparations, and apology. What made them uniquely successful, assuming that you believe they were, in the South African case? What might be a challenge to thinking about those three remedies when it comes to the United States?
Thanks, Steve. I mean, I think the South African Truth and Reconciliation Commission was established, and I mean, it also came about because of a compromise on the question of criminal accountability for the crimes of the past, remembering, of course, that apartheid was declared a crime against humanity. And so one of the issues that held up the signing of the interim agreement was really the fact that the generals on the apartheid side wanted a blanket amnesty. And of course, on the other side, the human rights lawyers were determined that they were not going to allow them to get off scot-free. And so the compromise, of course, was that there was a recognition really that there was no legitimacy really in terms of both parties sitting at the negotiations, but that this question would be decided later on when the new government came to power. And of course, this was based largely, I think, on the international framework at the time, the work of the French magistrate Louis Joinet, who spoke about, the fact that the inalienable right of victims to the truth about the past, also to criminal accountability, to reparations, and of course, the guarantee of non-repetition. And so in the South African case, and I mean, this was something that was discussed in South Africa over a period of 1 year. And that is really how the Truth Commission law was drafted. So on the one hand, you were dealing with perpetrators who had to make voluntary applications in which they made full disclosure about the crimes that they had participated in. And because these were done in a very public way, and victims had the right to oppose that, and in fact to have lawyers appointed for them to cross-examine these versions that perpetrators were putting forward. And that really allowed for, I would say, a national catharsis really around the question of the crimes of the past, but also an acknowledgement of what victims in South Africa had suffered. Now, of course, the commission was the first commission in the world to really deal with this in a public hearing fashion. And the commission did fashion a reparations policy, which it handed over to government. It also exercised its advisory powers in terms of the recommendations that it made to government. So I would say that, I mean, obviously in many societies, actually what has happened and what has gone wrong. But it's really different when you have an official commission that is appointed by government, which takes what it's hearing, and in fact that it turns that into an acknowledgement of what has happened in the past. And it also interrogates why this sort of crime has happened. And in fact, what it gives back to the nation is a narrative really about what happened in the past, who was responsible, and in fact, what needs to happen to repair that kind of society. And so I think from that perspective, the Commission's work certainly has been something that has been followed in many other parts of the world. But one of the issues that we are still grappling with now is the question of the other part of the constitutional promise, which was that if people had not applied for amnesty or had been refused amnesty, then the law would follow its course. And in fact, this is part of what we call the unfinished business in South Africa, and that really deals with the question of criminal accountability. So really the acknowledgement is important, but equally important is the question of reparations. And while you can never make up totally to victims for what they have lost, it's certainly an acknowledgement by the state of the harm and the wrongdoing that was experienced. But the bigger question is also, what measures do you put into place to ensure non-repetition? And I think that challenge of institutional reform around the security forces and the police is something which all of our societies are grappling with.
I think it's really interesting. I mean, two elements of what you just said. One is that even where there's knowledge of who did the wrong. There's a difference between knowledge and acknowledgement. But
Yeah.
also the piece about reparations. And of course, there's been quite a bit of writing here in the US recently. Nicole Hannah-Jones and Ta-Nehisi Coates have been writing about reparations and how it could be monetary, it could be structural, you know, putting more investment into schools and poor neighborhoods, and the kind of 40 acres and a mule idea, the Reconstruction era idea. But reparations could take a number of forms. It could be connected with the Truth Commission, like you said. And in the US, there are these kinds of reconciliation commissions. NPR did a story on apology, a whole hour. It was one of these like This American Life or Radio Lab kinds of hours where one story was a hospital that, you know, rather than you know, defending against lawsuits when patients had died, like in a case of a girl had died, they actually sat down with the parents and said, you know, we were wrong. We did an investigation. These are the things that went wrong. What can we do to make this better? You know, and oftentimes it's not only money that people want. They want the acknowledgement that a wrong was done. There was an injustice. And it was really analogous to the idea of a truth commission, that it can help the wrongdoer, you know, reintegrate, and because racism is really an evil for it distorts white people and society, right? And so it can be a way for everyone to move forward. And I think in the chat box, one of the questions was, could you imagine this being something with the police and Black Lives Matter? I mean, it could be a broader scale, or it could just be focused on the issue of policing, but it would be really interesting if, say, New York City, the next mayor, we have a mayor's race coming up, if they did a TRC in New York City with the NYPD, right? Or it could be national. But I think there's so many possibilities for structuring something along these lines.
Yeah, I mean, I remember many years ago coming to the States, I think, to participate. I think it was Greensboro that had a mini truth commission around the what had happened there with the Ku Klux Klan. And I think really important for people was the fact that they were able to speak about their experiences from their perspective. And I think really this is the kind of notion that the South African Truth Commission was also based on, the question of restorative and redistributive justice, because in as much as victims are locked in the pain, I think it was somebody like the Archbishop who also said that part of this process is also to allow perpetrators really to unburden themselves and to free themselves really from, you know, the way in which they've dehumanized people. And this is something, this process can allow them to unlock them, you know, what happened to them. And in fact, they then can become part of the country in which we live. And I think this was illustrated really by the fact that, you know, one of the things that President Mandela did when the commission handed over its final reports was he said that on behalf of the nation, he wants to apologize to the victims of our country for the pain and suffering they endured. And of course, when one contrasts that with the former President F.W. de Klerk, he was asked a question about what his government had done. And so he started off quite beautifully by saying, I apologize for all the bad things that have been done, but I refuse to accept responsibility for the crimes that people say were committed by my government, because my government did not commit these crimes. And if anybody believed that they had the orders or instructions to do so, then they were badly mistaken. And he went into a whole theory around bad apples. And by the end of it, he had lost not only Black South Africans, but also a white constituency that had expected him to lead them really into the new South Africa. And that sense of spectacular failure on the part of leadership, I think, was something really traumatic for many young white South Africans who expected him to say, listen, there were lots of things that went wrong, and these were the reasons these things happened. But they didn't expect him to come and say, I don't believe that apartheid was a crime against humanity, which is something he went on saying right up until this year when he was invited, I think, by an American bar association to speak. And we objected to that. And it was only after that that he began to say, well, he didn't know that the world had said that apartheid was a crime against humanity. And so the apology is absolutely critical, I think, but also all of us know what happens. We know what kind of racism takes place, but you really need those who are responsible for racism to embrace the fact that they were part of entrenching racism. And in fact, they have to say that they acknowledge what their responsibilities are. And I think here we go back to, someone like Carl Jaspers, who talks about different elements of responsibility at different levels. And I think that that's what I think is probably needed in the United States if this problem is ever going to be addressed, because it takes more than just changing law and policy. It really is also about a transformation of a society which takes responsibility for what's happened in its past.
And I think what's really key there about what you're saying is that it's not just about, individual accountability by individual wrongdoers, but, because in the United States, we have this debate about, well, if my great-great-grandfather owned slaves, why is that why should I be accountable? Yeah. But it's really a debt owed from society, like the way you explained Mandela conveyed that in the same way reparations were given to Japanese Americans who were a part of the internment during World War II. It's not as if this generation of people put Japanese Americans in concentration camps, but it is a debt that we owe to Japanese Americans as a society. And so it happens at many different levels, as you suggested.
Yeah, I mean, it's interesting that you raised that question of, the Japanese who got the reparations, because when one looks at this question of acknowledgement, the story of the Japanese comfort women, and of course, wow, the Japanese government tried through many different ways to pay the money, but without the acknowledgement that these women had been sexual slaves. That really broke the comfort women movement, because some of them were living in such destitutions that they were forced to accept the money, but others just refused it on the basis that if it did not come with the acknowledgement, they would not be able to accept it. So the way in which these issues work, you can't have the payment of reparations without an acknowledgement. And I think that's one of the lessons we need to transmit, actually.
Can I ask one last follow-up about the reparations, and then there's several really terrific questions in the box that I'll pass on as well. One of the issues surrounding the conversation about reparations is the question of the criteria and what a legislative framework would look like in terms of the recipients, and whether we're talking about individuals, how to identify individuals, whether we're talking about institutions, whether we're talking about programs. I just was wondering if, Yasmin, if you could offer any lessons from the success or failure of the South African attempts at reparations for identifying those who receive them and the challenge involved in that. Obviously, there's the resource question about whether you actually have the money to pay them, which is much more of a problem for South Africa than it is for the United States. But just in terms of figuring out who is the appropriate recipient of reparations, how has South Africa dealt with that, and are there any lessons for the US?
I mean, it's a really interesting question, and of course, the seminal sort of legal premise on that is really the UN guidelines on a basic remedy for victims. But in the South African context, of course, what the Act made provision for was that first you had to be declared a victim of a gross human rights violation, and it was only then that you would pass on to the Reparations Committee for them to consider whether you were entitled to reparations. And of course, the way in which it worked was that we said that if you suffered a violation, then of course you were entitled to reparation. And the notion of victim encompassed more than you, the actual victim, but also families, etc. And we devised a reparations program which looked at a cash payment for individual victims, but there was another component which looked at them accessing socioeconomic rights benefits like access to housing, healthcare, and of course, access by children to bursaries. But there was a very important element which we talked about, and that is community reparations, where there was an acknowledgement that many communities had been targeted during the apartheid period, and that in fact reparations should be recognized, that you're not only talking about individuals, but individuals who live in a community. But I think the important thing about reparations is that you can be fairly creative around it, and really it's an opportunity, I think, for a state to look at many different ways, and of course to consult with victims. And for this, I think back always to women in Sierra Leone. Sierra Leone was a very poor country, quite donor driven. All of the diamond wealth was being taken out of the country. And so when we had to look at the reparations question, we consulted with many of the women. And one of the things that the women asked for was law reform. A lot of them were married according to traditional rights or customary rights or Islamic law. And what they asked for was that the constitution should apply to them. They should be able to inherit land from male relatives. They should have access to the custody of their children. But they also made a very important point. They said that when we choose, we have to choose boy children to go to secondary school. And so usually our daughters don't have the opportunity to access that. And what we would like is for the government to set aside some money so that girl children can go to school. And I remember having to go and speak to the World Bank about the HIPIC program and ask them to make sure that a certain amount of that money would be appropriated and set aside for the tertiary education of girls. And so I do think that reparations is also about consultation, it's about memorialization, and it can take a whole host of non-monetary forms. But the biggest question is really that of recognition, and the notion that in awarding reparation, you're also saying to people that they are citizens in a country and that the government and all its institutions will actually work for them. So it's very much also about the restoration of trust in the institution of the state and of government to really work for people irrespective of who they are. And when you come from communities that have been extremely marginalized and brutally treated either because they belong to a different racial group or ethnic group, then I think that kind of the way in which the reparation is structured must take account of that acknowledgement and inclusion as well.
I hope certain presidential candidates are listening to what you're saying. So wise.
I'm going to try to group together three questions that seem like they're on a similar theme. One from Maya O'Meara, who's an MP, a master's in public policy student here at Michigan, who I think I just read her question since she says it better than I can. Many of the recent protests in the US have been internationally visible, with other countries leading marches in solidarity that both consider their own local issues of race equity and US racism and police violence. Does international pressure have the potential to impact American anti-racism movements, or have you seen that impact already? What international institutions do you think are most likely to make an impact? So both of you think about the international pressure and how that might lead to responses in the US. And then two comments that seem to be on the same lines, how Susan Gesh from Michigan, I believe, points out US speakers are familiar with how international human rights fora were used by activists and attorneys in the long saga of the Chicago police torture cases. By embarrassing the Bush administration, we were able to get the federal authorities in Chicago to finally prosecute the top cop in those cases. And then one of our faculty members, Ambassador Susan Page from the Fordham School and Law School, also brings up the same issue and asks about trauma healing as part of justice and reparations in the Chicago torture cases. So we can start with Catherine. What is your view about international pressure, either from official fora like UN bodies, Human Rights Council, treaty bodies, or marches organized by civil society, and whether they actually have an impact in the United States?
Right. I mean, I think that it does have an impact on a couple different levels. One is, I mean, if we think about it historically, the Justice Department filed a brief in the Brown v. Board of Ed case because the U.S. was embarrassed to be fighting for human rights in Europe during World War II. But then, you know, by the 50s in the U.S., Jim Crow was still alive and well. And, you know, along the way, we've seen how the juvenile death penalty in the U.S. was likely the Supreme Court abolished it because of, on some level, the international pressure, even if not the arguments that still the fact that the U.S. was one of like 5 countries that was still executing children was pretty embarrassing. And you know, justices travel abroad like many of the rest of us do. But you know, in the current context, Tendai Achiyomi, the UN Special Rapporteur on Racism, spoke to us the day after that urgent debate at the UN back in June. The American Society of International Law had its annual meeting around that time, and I moderated a panel that Tendai gave a report back, and it was pretty powerful, I think, to have George Floyd's brother speak. You know, he video conferenced into the hearing in Geneva. I think it's empowering for survivors, for those of us marching on the streets, the fact that there were 40,000 people marching in Paris in June. I think that helped to proliferate the demonstrations around the US, the fact that people were watching, that there was this solidarity, not only in solidarity with racism in the United States, but homegrown racism in France and abroad, as well as protests against US foreign policy to some extent. But so I think in terms of the organizing, in terms of lawmakers, I mean, the current occupant of the White House might not care as much about international pressure, but other lawmakers do, certainly. And we've seen that in the past. And I think it is meaningful.
Yasmin, the issue of, I mean, we know how international pressures was so important for South Africa, but for a country like the United States, in a very different place in terms of its mistrust of international institutions, dislike of anybody telling us, or at least some people don't like to be told that another country is doing something better, whether it's about civil rights, human rights, or epidemiology. How might foreign protests or condemnations play a role here?
I think, you know, as Catherine said, I mean, even though people at some levels might not like that interference, but the fact of the matter is that it's you know, you have these historic moments, and of course, when the Human Rights Council had this historic debate on what was happening with the Black Lives Matter movement, and of course with George Floyd's death, that's a seminal moment. Because the US is being, in a sense, reviewed by its peers. You have member states around the world, and they're actually saying that there's something wrong in your country and you need to pay attention to it. And of course, when the special rapporteur begins to prepare a report on your country, once that report is done, at some point you're going to come before the Human Rights Council, you're going to be peer reviewed. And so all of that does make a difference. And I give you another example. I mean, the fact that when your sportsmen started to kneel, you know, and really acknowledge the fact that you had so many Black people dying in America who've been shot by the police, this has inspired sports people all over the world. And certainly in my own country, it gave young Black cricketers who've been part of the national sports team the opportunity not only to join in solidarity, but actually to use that moment to have a conversation about structural racism in sports, in the cricket space in South Africa as well. So much so that in the last week, a colleague of mine who was on the Truth Commission has been appointed as the new ombudsman to deal exactly with these sorts of things. And of course, you know, people travel, like Catherine said. Judges are going to hear from other judges that, in fact, the US risks being a pariah state unless they begin to take to deal with these issues. And in my country, of course, I came from a home where my father was part of the caste group, which didn't believe that you could play sports in an abnormal society. And of course, we were very much a part of the boycott movement. And while we know that, in fact, it was the battles on the borders of South Africa when the body bags were coming home, it was also the fact that white people couldn't play sports, they couldn't participate in international activities, that really drove home the point to many South Africans at home that apartheid had to go because it was not serving them. And so very much in the same way, I think what we've seen is that the solidarity protest, the action by the Human Rights Council, by the special rapporteurs, I think the work that someone like Philip Alston has already done around the question of torture and extreme poverty and the fact that it's racialized, I think all of these initiatives will begin to unlock a discussion, which I think is part of how we all then begin to support a movement for change. And you see that happening in the council already. I mean, I think let's not, I think a lot of US diplomats are conscious of the fact that sometimes they can't even put forward the kind of unconscionable policies that the administration is setting up. And so if you want to be a power for change, you also have to embrace that in the way in which you deal with stuff domestically. And I think that's we're going to see happening. This is unchangeable. You can't move back. And I think this force is going to carry on.
Okay. Another question from a Jessica Eller, who is a master's student at the LBJ School at the University of Texas and an alum of our Ford School. Returning to the question of remedies, besides possible Truth and Reconciliation Commission and reparations, what main structural changes should future policymakers be considering focusing on for achieving racial justice in the US? And I would just add on to that, what does the practice of international institutions or other countries suggest should be the structural changes that the US should be looking at? So Catherine, you want to have a few thoughts on that one?
Yeah, it's a really big question, and I think all of us are asking this question. I'm on sabbatical this year and working with a coalition of civil rights groups on a sort of racially just economic recovery plan. There are a lot of calls for a feminist economic recovery, and on a parallel track, we just at the beginning of the summer started talking about this idea of putting together almost like a blue ribbon or Kerner Commission type report on civil rights in an age of COVID, and that very quickly expanded to civil rights in an age of pandemic. And it got really big. And then we realized, okay, if we're going to do this before the election, maybe we better focus in on one element. So we're really focused on the economic recovery because, of course, that cuts across so many different issues, including the health crisis, employment, returning to school, et cetera. There's a lot of talk about building back better, right? Not returning to normal, but or what was normal, ex ante, but trying to develop a more just economy that addresses these equality issues, economic inequality, as well as race and gender inequality. And so we want to try to really focus in on the race part, or else that won't be part of the conversation necessarily. We've seen bailouts of the airlines, but the stimulus package, those checks have dried up now. So I think it's necessary to have a broad conversation involving lots of stakeholders. And so rather than give an answer, I'll say that I'm very interested in sort of engaging in this process with grassroots activists and all kinds of expertise to try to identify solutions. I think we're going to have to see some change in Washington to, at least on the national level. And we've seen how the failure of national coordination in COVID has been such a disaster in terms of testing and contact tracing and so forth. So I really think we need a change at the national level in order to have a more coordinated response for many of these large issues. But fortunately, we do see on the policing issue and other issues, some reform at the state and local government level as well.
Yasmin, on the issues of structural reform that might be of where the U.S. might be benefiting from the practice of other states. We only got about 3 minutes, so unfortunately we'll have to keep it a little short.
Yeah, I mean, I think the economic questions are important, and really one has to understand how the structure of the economy has really affected, and how race is a key factor in the way in which that affects people who are the most marginalized. And I remember, I think, a US economist recently speaking about a housing assessment that she did, where she saw that white people benefited from access to loans, but Black people's housing estates were redlined. And so when you look at property as some kind of access to the economy, then of course, quite often, quite frankly, you're marginalized immediately. And so when we talk about generations working their way out of poverty, I think it's quite critical then to look at the way in which the economy is structured. But I think a lot of that kind of research and discussions are happening at the US level as well. And of course, when we do that, to think about how race and gender affect the way in which the economy actually works.
Thanks very much. Well, I am sorry that we've run out of time, because we were just getting started and we could easily have gone on for much more time. But I want to first thank our audience for listening and for being here and for the great questions. I apologize to those whose questions we couldn't answer, but the conversation will continue. I'd like to thank Brinna at the Donia Center, of course, for helping to put this together, and especially thanks you to Yasmin Suka and Catherine Powell for joining us today, taking time from their very busy lives in New York and in Johannesburg to join us for this event. I think it was a really educational experience for all of us. We look forward to welcoming you back to future Donia events. To all of you who are listening, thanks very much. Our next event will be on Thursday, the 15th of October, on COVID and human rights, featuring public health and human rights specialists to talk about the impact of the pandemic on the enjoyment of human rights and the impact of the right to health on responses to COVID. So we look forward to having some of you back for that event. And in the meantime, thank you very much.